We hear of a lot of misconceptions that tenants have regarding the law, and they're right. One thing that we hear on a regular basis is tenants seem to think that they can't be evicted until they're 30 days late on their rent. And unfortunately, that's not true. If you have not paid your rent and it is late, your landlord can immediately give you a 3-day notice. It's important that, first of all, this notice is accurate and references the amount of rent that's owed. It's also important that this notice is a written notice. A text does not work. And actually, if you look at our website, we have blank forms that you can use, and one of those is a 3-day notice that you can just print out and fill out. And upon receipt of that 3-day notice, you have 3 days to pay all of your rent. If you do not pay your rent within that 3 days, your landlord can immediately file an eviction action against you upon the expiration of that time frame. An eviction could be filed within as few as 4 to 5 days after your payment has not been made. You cannot accept partial rent. You must accept the full amount of rent only. If you accept partial rent, you have to provide a brand new 3-day notice with the updated amount of rent, and it's only going to delay the eviction action. After you receive a final judgment, then the court will issue a writ of possession. The writ of possession will go to a sheriff's office, and the sheriff's office will post the writ of possession required to give the tenant 24-hour notice. Oftentimes, the sheriff will give them 48 hours notice. Then they'll come back. They'll actually call you as a landlord to schedule a time to come back and make sure that your tenant has vacated the property. If they have not vacated the property, they will force the tenant to vacate the property. Unfortunately, if that's the case, you will have to have somebody present to remove all of their personal belongings and put them at the curb at that time so the tenant can then remove them from the property. So what happens if your tenant contacts you and says, I can't pay my rent? I often recommend to my clients that you try and resolve this with your tenant and see if you can work out an arrangement where they agree to vacate so you don't have to file the eviction. Now, even though your lease agreement is going to say that you're entitled to reimbursement of attorney's fees and court costs and eviction action, your tenant is not going to have the money to reimburse you. And quite frankly, they're likely not going to be collectible. So there's a good chance that you're never going to receive reimbursement of those funds, which is why a lot of times I'll tell people to work with their tenant and try and give their tenant maybe a couple days to get out. And if their tenant can get out, then they can go ahead and file the eviction action at that time. Don't be afraid to talk to your tenant and try and come to terms to settle the matter. Another misconception we have heard often is that my lease automatically renews after the first year. That's also not the case. Your lease is usually for a 1-year basis or 1-year term, and the expiration of that term, your lease will then turn into a month-to-month lease. And what that means is you still pay your rent on a monthly basis, but you're not guaranteed the right to live in the property for any specific term. How do you terminate that lease agreement? First of all, if your tenant is on a month-to-month lease, you technically can terminate the lease agreement at any time by providing 15 days written notice prior to the end of the month. Oftentimes, people will give a 30-day notice to terminate. I highly recommend that it be in writing. Again, texting is not acceptable. It needs to be in writing. The notice of termination needs to be hand-delivered to your tenant, or it needs to be posted on their door if they're not present. Make 2 copies of the notice of termination so you can keep one for your records. And if you do post a notice on your tenant's door, make sure you take a picture of it posted on their door. If your tenant does not move out by the date referenced in the notice of termination, you can file suit for eviction. Your tenant is then considered a holdover tenant. You are entitled to double rent for the amount of time that they reside in the property after the termination. It's important that you either make arrangements with your tenant to move out within a timely manner, and those arrangements are written and signed by both parties, or you proceed with your eviction action. If you allow your tenant to reside in the property after you've already given them the notice of termination, you may have to give them a new notice of termination after that to ensure that it's proper notice prior to filing an eviction action. Another common misconception is my landlord cannot increase my rent. Unless you're on a 1-year lease that is fully executed, your landlord can increase your rent. Your landlord can increase your rent every single month if they would like, as long as your landlord gives you 15-day notice. And unfortunately, there's not a cap on how much your landlord can increase the rent. They can increase the rent to whatever they perceive as market rate.